in 1990, the Immigration Act was introduced, but I think it was implemented in 1992. And it provided athletes and entertainers a more effective way of entering to the United States to compete. The Immigration Act of 1990 created two categories, the O and the P. Could you tell the audience exactly what the O and P visas are?
So the O visa is reserved for individuals of extraordinary ability. It's one of the few visas that has a very, very high legal standard, because essentially we need to prove that the athlete or the entertainer or the artist has reached the top 2 or 3% of his or her field and has sustained a high level of distinction. That basically means that we need to prove that the person is the top of the top. And sometimes you have people who are extremely qualified for the O visa who just cannot make that high legal threshold. U.S. Immigration officers are increasingly scrutinizing petitions nowadays, and they are applying the law very, very inaccurately and very, very severely, often resulting in those who are qualified not securing the visa.
Oh, interesting.
Unfortunately. The P visa is reserved for entertainers, for groups that will be touring, and for athletes. It has a smaller validity period compared to the O1, but the process of proving the distinction of the beneficiary is very similar to the O visa. The major difference between the P and the O is the validity period, which is why entertainers, athletes, and artists try to seek out the O visa, because it gives the beneficiary a longer period of stay in the U.S.
Okay, very good. For these visas, I think there's a recommendation letter, stating why this athlete needs to be here.
Definitely.
And why they have a special ability other than anybody else. And what I explained was that, we need such great international talent to draw in an audience. And then with a new audience that likes the sport, it builds up a new business. So we could hire local people to manage the teams, run the concession stands, and build new other business surrounding the sport. So when we went through the O1 route, it was better, and we got it expedited. We had 2 weeks to bring them in, and they were able to come and perform at Madison Square Garden. So that's my little experience between the O1 and P visas.
Yeah, and I think that was a very positive strategic move on your part, because not only were you able to highlight the uniqueness of this new league and how forward-thinking it was and what a pioneer it was in the field, you were also able to highlight the extraordinary achievement of your client or the athlete and why he or she would positively impact this new league that you were creating.
Absolutely, absolutely. Now, would you have any stories about any O1 cases that you've had that may have been difficult, or any interesting tidbits in handling O visas?
Sure. So it's interesting that you mentioned the letters of recommendation, which in the O1 world are known as testimonial letters from experts in the field.
There you go.
I've written expert letters on behalf of some very, very famous people in the fashion industry, in the music industry, and so not so famous people. And one trend that I'm seeing with USCIS is that they are starting to reject these expert letters, stating that these letters written by experts are not sufficient to demonstrate that the beneficiary, that the client, has reached a high level of success in his or her field. And if you think about it in the real world, it sounds preposterous, because if Bill Gates were to write a letter of recommendation on behalf of one of his employees, that letter in itself is recognition that that person has done a good job, because no way would Bill Gates write a positive letter on behalf of somebody who hasn't accomplished something positively for his company. So the fact that they're rejecting these letters, which are very difficult to write, because you really need to understand the profile of the beneficiary. You really need to understand the impact that the beneficiary has made in his or her industry, and the future impact that he will make or she will make in the U.S. and the company that will be hiring him or her. So it's very disappointing that these letters are being rejected, because they are prime evidence, it's prime documentary support to prove that the beneficiary is a leader in his or her field.
Oh, very good. Let's talk about certain celebrities that have very interesting immigration stories. We'll work a little backwards. We'll work from the past, and then we talk certain things about some recent stories. Now, I'm a big comic book fan, and I love Superman.
My name is Elektra.
Oh, that's right. That's right. That's awesome. The person who made Superman, right, is an immigrant from Toronto, Canada. And his name is Joe Shuster, and he's an immigrant that contributed greatly to our comic book story. Superman's the first superhero. So it's another story of how immigrants can enrich. As a Canadian, enriching such great American culture.
Definitely. And I tell this to my staff, and I tell this to anybody that I meet. Our firm is directly impacting the cultural and artistic landscape here in the U.S. I represent Broadway performers. I represent top PR executives that are working with top brands in fashion. I represent fashion designers, jewelry designers who've exhibited in top museums and in top exhibitions and galleries here in the U.S. These immigrants, these foreign nationals are changing the way we are understanding and the way we are perceiving art. Art has always been inclusive, just like immigration has always been inclusive of different viewpoints and styles and ideas. And when you have foreign nationals come and bring their ideas and bring their history and bring their language and bring their story, they're directly changing what American art is considered today.
Another special immigrant is Lupita Nyong'o. I always mess up her last name, but you remember her from 12 Years a Slave and Black Panther. Her story was, she was born in Mexico. And she moved to Kenya with her family, and when she was very young.
Well, she is actually a true example of a global citizen, because I represent many Mexican nationals. And when she actually won the Academy Award for Best Actress or Best Supporting Actress, all of Mexico was repping her because they had finally felt like they were represented in the arts. And for maybe somebody in America, that sounds kind of counterintuitive, because she was only born there. She was raised in Kenya, but she is fully embraced by the Mexican community.
That's very interesting.
Yeah, which I think is wonderful.
That is wonderful.
It's truly representative of somebody who is a true forward thinker and leader in the global sphere.
I like that term, global citizen, right? That's what she really is. Okay, I think that's fantastic. Great story.
Yeah, Amy Winehouse is probably the most famous celebrity who's been denied a visa to perform here in the U.S., which everybody, I'm sure, comes as a shock to everybody, because she has directly influenced pop music and R&B music, and is considered to be probably one of the most influential and important singers of our time. But she was actually denied a visa because she was deemed a threat to the U.S. because of her unfortunate drug and alcohol abuse. So unfortunately, because her visa was denied, she couldn't perform at the Grammys.
So they would consider that a threat to the U.S. because she had personal substance issues?
Well, when you have to apply at the consulate, which is governed by the Department of State, you need to disclose any arrests that have occurred and why you've been arrested. Usually when you go in for the consular appointment, for the consular interview, the immigration officer or the consular officer will ask you different questions about your arrest and why you were arrested, because the consular interview is really the opportunity for the Department of State to weed out who has good or proper moral character and who is deemed fit enough to come into the U.S. She did not pass her interview because she had to disclose her drug arrests or her drug convictions, was subsequently denied and could not perform at the Grammys. Much to the disappointment of everybody in the entertainment world.
I'm sure. God rest her soul. With a superstar, that's a little disappointing that she couldn't perform for her fans. 21 Savage has an interesting story, and I did not know he was a Brit.
It came as a shock to everybody. You're not the only one.
So tell us a little bit about it and as to the what happened.
So because it's a relatively new story, there are lots of different facts. But what I've gathered is he has represented himself to the entertainment world as somebody being from Atlanta, as a rapper or a hip-hop artist being from Atlanta, which is very convenient for him because a lot of prominent rappers, such as Migos, for example, are from Atlanta. So right now it's kind of like a hot hub for people who want to emerge in the music world.
For sure.
So he represented himself as somebody who was from Atlanta, and he was recently stopped, and now he's in a detention center because a police officer ran a background check and realized that he was an overstay. basically an overstay is when somebody comes into the U.S. with an ESTA or a B1 or B2 visa, which is a tourist visa, and they overstay that visa. Typically, these visas last for 6 months. You can extend them for another 6 months. He overstayed. Once you overstay, that is technically a deportable offense, and he's been here ever since.
How long has been his overstay?
He arrived here in 2005 when he was quite young.
Yes.
So he's 26 now. So that would be maybe when he was 12, 13.
Oh, wow.
Which is probably why he doesn't have a strong British accent, if he still has one at all.
Now, this is when, correct me if I'm wrong, is it that, the longer you're an overstay, do they apply that same number of years of where you're not allowed to apply to come back to the U.S.?
Definitely. So the longer you overstay, so in his case, he's overstayed, we're into that 13 years, he would be subject to the permanent ban, which means that if he goes back or if he's repatriated to his home country, to the UK, he will be subject to a permanent ban.
Oh.
The only way to overcome that ban is if he has a qualifying relative, so either a U.S. citizen spouse who waivers for him, who petitions for him. He gets an I-130 approved, proving that he has a U.S. citizen spouse. And then a waiver is basically a pardon to the government, saying, yes, we acknowledge that he has overstayed his visa. However, I, as a qualifying relative, the U.S. citizen, will suffer extreme hardship if he were to go back to his home country.
So because I don't think he's married now, but if he quickly got married to a U.S. citizen, would that save him, or people would kind of, would though the powers that be see that as trying to circumvent the law?
No, if he is in a relationship and decides to take it to the next level, then he can do that. But there are processing times involved. So in order to seek relief based on him having a qualifying relative, he will need to file an I-130 application. That petition is taking about 12 to 13 months to be approved. Once that is approved, then he can seek relief from the immigration judge.
All right. Interesting. Well, 21, good luck to you. Hopefully things work out. And not sure if you're going to hear this, but hey, good luck, buddy.